Good evening, ladies and gentlemen, everyone who has joined us. So today it's our fortune to have with us Mr. Anubhav Raj Shekhar. Now, Anubhav has been a close friend of mine since college days, and he's currently an assistant professor and assistant dean at the General Global Law School. In addition to that, giving just to give you a background of what he does and what he has done so far. So he's a law graduate from the National Law Institute, University Bhopal. After that, he also pursued an LLM in Law and Development from the Azim Premji University, and after which he has also read his MSc at the University of Oxford in South Asian Studies. Among other major areas of his research, the research on the jurisprudential aspects of death penalty in India is one of his favorites. So I think it's very apt that we have chosen the same topic for today's lecture as well. So just to give Anubhav also an idea of what the next 1 hour entails. This is a group of lawyers from majorly from Jammu and Kashmir, and a vast majority of us are young lawyers, but we are also joined by certain senior lawyers, and sometimes an occasional judge also joins in for the lecture. So it's a very niche audience, so to speak, which is very connected with the practice of laws. So today's topic, because it entails jurisprudential aspects of law majorly, is a slight departure from what we do otherwise. Otherwise, we call practicing lawyers who generally lecture about practice areas wherein we need help. So, without further ado, I will ask Anubhav to like set the tone for today's interaction by a short lecture, which would of course be followed by an open session where everybody would be encouraged to ask questions. So, Anubhav, you can start, please.
Sure. First of all, thank you so much for having me here. It's indeed a pleasure to have been invited to speak to such august audience, and I hope I'm able to do justice to this assignment. And by the end of our engagement, we all leave enriched with some understanding of how death penalty functions in India. Now, having said that, I was before this conversation, before this um, event, Fahad and I were speaking, and there were certain areas which we spoke about that would be interesting and relevant to discuss. And of course, I mean, there are lawyers here, and lawyers are better suited to speak exactly about how the procedure works. So there are certain um, aspects about death penalty and how death penalty is looked into globally and as well as the national level here in India, that shall be the focus of my discussion in today's lecture. Now, one of the point is what is the purpose of capital punishment, and how does capital punishment feature in a civilized society in India and abroad. So uh, allow me to begin by speaking a bit on the purpose of criminal law. And when we look at criminal law, there is no denial of the fact that the purpose of having a criminal justice machinery is to suppress crime in a society, so that we are able to create an environment where humanity can function without any fear. However, the mechanism in which crime suppression works is really determinant of how individuals interact with the state, and more specifically the criminal justice machinery. For example, um, there are two models of criminal processes. There's one I would like to quote, or rather invoke Herbert Packer, who has written um, a seminal article called Two Processes of Crime Control, uh, Two Models of Crime Control. And in this article, um, Herbert Packer gives us two typologies, two models of how crime, how these criminal process models work. First model is crime control model, and the second model is due process model. Now, within crime control model, Packer says that the idea is to create a criminal justice machinery system where the system is geared towards suppressing crimes, and the other model is the due process model. That while both models agree in the fact that yes, crime needs to be suppressed, but the due process is more rights oriented, whereby it will ensure that at every stage there are rights for the accused, there are hurdles that are created for the state before it is able to convict a person and deprive them of their right to life and personal liberty, um, or rather just personal liberty. Having said that, the important question is that is death penalty or should death penalty still be considered a part of civilized society? Now, allow me to quote a few statistics. As of 2022, global trend, as of end of 2022, global trend is against the death penalty. For example, over 110 countries have abolished it. By the end of 2022, there were about 55 countries which were retaining the capital punishment, which of course include India and the US as two big democracies. Um, in fact, you'll be surprised to know that in 2022, New Papua Guinea, Central African Republic, Zambia, they abolished the death penalty. In fact, um, Malaysia has also abolished mandatory death penalty. Ghana in 2023 became the 29th African country to abolish the capital punishment. Now, despite this, I mean, if you look at these statistics, you would tend to think that globally, at least, there's a trend against capital punishment. But in India, death penalty still remains vastly popular. Right? You would know that there's several crimes for which death penalty is imposed in our country, mostly homicidal crimes, but there could be some non-homicidal crimes as well. But if that is the case, where on one end the global trend is against capital punishment, then what is the reason why in India death penalty remains so popular? The answer, well, it is a tricky question to answer, no doubt about that. But it does seem that society seems to be functioning under some assumptions. Um, there are, as lawyers, we are all privy that there are different theories of punishment. For example, there is deterrence theory, there is reformation theory, there's retributive theory, and in if you look at popular media, whenever there is a case on capital punishment, it is said that, or if there is, especially in sexual offenses, the first demand is that there should be capital punishment, which should be accorded to the um, to the to the convict in the specific case. Now, the assumption is that it would lead to a deterrent effect on the society, and that people are going to be we're going to fear and they are going to think before committing such a crime. But there, as per the studies that have been conducted, there has been no convincing relationship that has been found between deterrence and capital punishment. So it is not necessary that capital punishment would necessarily lead to deterrence. And you could do a study about, for example, sexual offenses, if the changes that have been brought, um, or in cases where in countries where death penalty is, in America for that matter, has crime really gone down, which very liberally has been using the capital punishment, even more liberally than India has. Because if you look, since the turn of the new century, India has hardly executed 8 people. If you look at judicial executions, and I'm not speaking about encounters here, which is a complete debate because those are non-judicial killings, so they do not fall within the purview of death penalty studies. Um, so, for one answer is this false assumption that death penalty will have a deterrent effect, because there is no study to show that yes, there's a significant change. Second, the assumption that there is that a person before committing a crime does a mathematical calculation in the mind that, if I do this, it would entail this much punishment. But actually, that is false. a criminal does not, or a person who is going to commit a crime does not actually think about the consequences every time before they to commit. Therefore, on that logic also, deterrent effect does not seem to be working. And the one very interesting facet is the fact that death penalty seems to be the easy answer to a lot of things, because the public is happy for once. The public thinks that justice has happened, um, um, and therefore it sort of tries to negate any role that the society has played in the creation of that person who has committed that heinous offense, which is a capital offense. And um, That is one feature which is not spoken enough as to what are the structural issues. How does society create structures whereby a person who does not have access to privilege, or a person who succumbs to their circumstances, ends up committing such an offense? So perhaps society needs to reflect as well, which the society does not want to do, and therefore death penalty seems to be an easy answer. So on all these counts, death penalty becomes very, very popular in India. Now, since I'm speaking um, about uh, privilege, and I'm speaking about the fact that society does not consider the structural issues, I want to support this argument with a with some data, in fact, here. And the data that I want to put before you is a study, a very interesting study, in fact. And I would request you, if you haven't already, I'm sure many of us present here would have heard about this study, or at least the project. And if you haven't checked it out, I would sincerely urge you to look at it. This project called Project 39A, which is housed at um, National University at Delhi, which conducted the a study, and which culminated into the Death Penalty India report. Now, the Death Penalty India report created a social profile of the prisoners who are on death row, and the results are very interesting, because it was found that 74% of the people who were on death row in 2016, when the report was published. Now it is opportune time for perhaps to conduct another such survey and find out if the data is still pretty much the same. And my hypothesis is that even if you do it today, it would come out to be very similar to what the data is. The data found that 74% of the people were actually economically vulnerable on capital punishment. Over 40% were roughly 40% were sole earners. 33.3% of the individuals on capital punishment were belonging to the OBC category. 23.6% were SC/ST, and a substantial chunk also belonged to religious minorities. Therefore, it appears that the system, the criminal justice machinery and the death penalty machinery, there's not a lot of fairness in it. And therefore, this question of finding fairness in death penalty keeps coming up. How do you make the process more fair? Because if you're not able to make this process fair and just, it falls foul of Article 14 and Article 21, which mentions that no person shall be deprived of their life and personal liberty except according to procedure established by law. So, what is this process? This procedure has to be just, fair, and reasonable, right? But it seems that identity seems to be playing a role here, because if people who are marginalized, people who belong to minorities, people who are economically vulnerable, they are becoming the target, whether consciously or unconsciously, of capital punishment, then such questions would arise, which are being spoken about through this project. Another very interesting thing is that because people are economically vulnerable, marginalized, certainly it is very difficult for them to secure representation within the courts. Um, And as you would be aware that that a person can go right from the Sessions Court all the way to the Supreme Court. Generally, that is what happens in death penalty cases. And then there's also scope for we'll discuss it, of pardoning. But in all this process, you require resources, and it seems difficult if 74% people are economically vulnerable. It seems very difficult for a person to be able to secure the necessary wherewithal, or to represent themselves in a meaningful manner. And you're aware that the per capita spending on legal aid in India is abysmal. It is nearly non-existent, although there are processes in place, of course. And 13 Article 39A provides gives a mandate to the state to provide legal representation to people. In fact, in one of the judgments, the Supreme Court has said that legal aid for the poor should not mean poor legal aid. So even if legal aid is being given to the poor, it should not mean that the quality of the legal aid uh, should be subpar. But unfortunately, we all aware how short legal aid services fall when it comes to providing meaningful representation to people. Um, uh, in addition to this, there is a question of uh, uh, how many people are there on death row. That's one question. And the second question is, how much time do people spend on death row? Uh, the I'll answer the first question first, of certainly. And if you look at the data, as I've said, that there are roughly 8 people who have been executed since the turn of the new century, which means in the last 24 years, only 8 people um, have been executed in India. However, this data does not represent how the death penalty machinery functions. Starting 2006 up till 2022, if you look at the number of people who have received death penalty, the numbers are staggering. For example, in 2016, 400 people got death penalty in India. 2017, there were 366 people on death row in India. 2018, there were 426 people on death row in India. 2019, there were 378 people on death row in India. In 2020, there were 404 people in death row in India. 2021, there were 490 people on death row in India. 2022, 31st December, there were 539 people on death row in India, which means that there's a substantial number of people on death row. And and why is this problematic? Because this goes back to the question of what is different about death penalty. How is it different from any other form of penalty that there exists, right? How is it different from um, a life imprisonment, right? And there have been scores and scores of literature that has been written on why it is different, on why it is not different, or why life imprisonment is also equally cruel. And one sound argument that I found was based on this theory called terror management theory. Because the moment you tell a person, see, all of us live lives meaningfully, thinking that our lives have a purpose, and we think that we are going to leave a mark on this society. And the fact that we are not aware of when we are going to die, right? So when we are not aware of when we are going to die, it appears that there is a long life, meaningful life to live where we can contribute. But if death becomes certain, and a person knows that now death is inevitable, and mind you, these are people on death row, are people who are mostly illiterate. They are not aware of the processes. They don't know how if they can trust the state. So every day becomes like the last day. And therefore, this terror management that we as a society are able to do so easily, because we are just not certain of when death would come. And Supreme Court itself has said that death is a very much a part of life, and which nobody can escape. But um, then it becomes every day becomes like a last day. And I'm sure you would know that the famous Ghalib Sher, which in fact Markande Karju had also quoted in Arna Shanbog, which is मरते हैं आरजू में मौत की, मौत आती है पर आती नहीं है. तो आप हर दिन ऐसे जी रहे हैं कि जैसे आखिरी ही दिन है, अब हर लम्हे में मौत है पर तभी मौत आ नहीं रही है. So death penalty phenomena has, in different contexts, in American context, it has been, and on different through different studies, it has been found that it could lead to a loss of mental stability, and in most cases it does. Um, but why does it do so? How does death penalty phenomena lead to a loss of mental stability, and why does it do so? The answer to that question is, if this entire process was a short process, which would which would finish, or which would um, where the process would have been short, and you know that it is certain, then perhaps there would be some respite. But if you look at the data again, which is coming from Project 39A's work, um, if you look at the data, you will find that uh, at the high court level. Now, let me take a step back and tell you how the death penalty actually functions before telling you how much time it is taken. Every time a sessions court, generally a sessions court, when they sentence a person to death, that sentence needs to be confirmed by the high court, and two judges sit, and they either confirm it unanimously, and if either of them disagree, it will go to a third judge, and then the decision is taken. Now, after that, of course, you can appeal to the Supreme Court under different procedures, and then there is further there is review, and there is curative, and then there are mercy petitions with the executive, and lastly there are post mercy proceedings which come back to the High Court and the Supreme Court. Now, at these four stages of High Court, Supreme Court, then mercy petition, and post mercy proceeding, allow me to tell you how much time do prisoners on an average spend, right? And for prisoners who were on death row on 31st December 2022, Project 39A said that for confirmation proceedings, the median was 44 months. 44 months for confirmation proceedings was the median, and the maximum duration in a case was 172 months. 172 months, we can convert it into years. It will be more than it will be 11 years. Then sorry, it will be much more than 11 years actually. Then uh, at the Supreme Court level, criminal appeal and other related proceedings, it has been found that the average, the median is 69.5 months, nearly 70 months, over 5 years, 5.5 years of time. Um, um, After that, the maximum time in a case at the Supreme Court level was 298 months. For mercy petitions, the average is 148 months. For post mercy proceedings at High Court and Supreme Court level, the average is 192 months. Now imagine if you add all these, 44 plus 69, 44 at High Court, 69, 70 at Supreme Court, then 148 months at mercy proceeding, and then post mercy proceeding 192 months. You can imagine the time span that a person is spending on death row, and thereby going through the death penalty phenomena. And within jails also, prisoners who are on death row are treated significantly different from other prisoners. Therefore, it becomes even more difficult for them to survive in such a um, um, such a situation. Now, before I will not take a lot of time. I understand it's a Sunday evening, and it's already it's 8:30. So I'm brief make it uh, um, to make it concise. But one last question that I would answer is, how does the court decide in what case should the death penalty be given? And the death penalty, um, uh, for a court to decide, the decision of Bachchan Singh versus State of Punjab is critical to understand that. Bachchan Singh case of 1980, the Supreme Court said that um, death penalty can be given in the rarest of rare case where all other options are unquestioningly foreclosed. That's the complete standard that has been given by the Supreme Court. It's not just rarest of the case. The answer is rarest of the rare case where all other options are unquestioningly foreclosed. So the question becomes, what does it mean? When do all options are unquestioningly foreclosed, right? If two judges of the high court, out of the confirmation proceeding, if one judge disagrees, does it become questionable, or does it remain unquestionable, or do we follow the same process of the majority in the bench, right? Therefore that remains unresolved. Secondly, what does rarest of the rare mean? So in that case, there are mitigating circumstances and there are aggravating circumstances. And courts in different cases have said that what are mitigating circumstances? If the person who is convicted and sentenced is too young, too old, mentally unstable, so on and so forth. Aggravating circumstances, on the other hand, there's also a list that is, I mean, in different cases, depending on how the crime was conducted, if it was premeditated, etc., and so on and so forth. But the controversy remains that do you have to really balance it out, or you have to look at even if one mitigating circumstance is present, you have to commute the capital punishment. And a lot of people are of the view that even if one mitigating circumstance is present, you have to commute that person, right? And um, in addition to this, there is a concept of public conscience in question of death penalty. You would have heard this phrase again and again, that death penalty should be given because it has shocked the conscience of the society. This shocking the conscience of the society is not given by the Bachchan Singh doctrine, and therefore, and this is problematic because then it becomes less about what the case says on the file and more about what the society wants. And you are well aware of different cases. I'll give you an example of the Hyderabad encounter in 2018. A women against whom sexual offenses were conducted, there were 4 people who were encountered by the police in Hyderabad, and then there was mass celebration, and in fact flowers were showered on the police officer. Later on, the judicial inquiry was conducted and the inquiry concluded saying that the encounters were fake. Therefore even the public could be happy, but it is not necessarily that it will result in justice in all cases. Therefore this Machi Singh doctrine of which is a 1982 case, which says that you can take into consideration the conscience of the society, it becomes very problematic. And in almost all cases where death penalty has been given in this century as well, the conscience of the society, this doctrine has been invoked. You can read Mukesh versus NCT of Delhi, even in that case, or you can read for any other case for that matter, and you'll find that it's a cry of the society. This is even after this judgment of Machi Singh has been held to be per incurium by the Supreme Court in Santosh Kumar Bariyar case. This is after a number of judges wrote to the president that the decisions were earlier based on Machi Singh doctrine and therefore they should be recalled. But despite that, the Machi Singh doctrine seems to hold a lot of ground. Therefore, this is a tussle between constitutional rights versus what the society is asking for. Um, so, having said that, I think I'm going to stop there. I would have spoken for roughly half an hour if I'm not. We started at 8:05. It's 8:35. We'll take a few questions and then perhaps yeah. Thank you. Fahad.
So, yeah, thank you, Anubhav. It was very concise on your part. And can you hear me? Yeah, so it was very concise on your part to have condensed this lecture in 30 minutes, where you touched upon multiple aspects of death penalty, including the doctrinal aspects as well. But when you express a stated position that you are against death penalty, it also means that you have a very strong stance against the deterrent theory when it comes to death penalty. My question would be precise. Why do you think that death penalty is not a good deterrent when it comes to heinous crimes?
All right. So I'll answer that. First of all, um, the direct answer to that question was would be uh, in what scenario is the death penalty operational? If the death penalty was operational in a perfectly just system, then perhaps I could have gone on to the second question of whether death penalty has a deterrent effect or not. But the fact that the odds are so much against a majority section of the society who do not have the resources, therefore, this question of deterrence would be secondary after we are able to tell that the system in itself is just, fair, and reasonable, right? And because the system does not seem to be just fair and reasonable, and again, I'm not talking about cases, individual cases here. You can say that, generally when I say this, I get questions like, but what about that case? Would you oppose death penalty in that, in cases of sexual offense? And then they'll refer to a specific sexual offense which became popular or infamous, and say, do you support that rape? Are you trying to say that? The answer is no. My answer is based for in light of those 500, 600 people who are in jail, about whom we don't know anything at this stage, but they do not have an equal chance before the courts, right? And because of the death penalty phenomena, the long time period that people spend, and the difference between death penalty and other punishments that I have already spoken about, and also the fact that deterrence effect, there has been no study. If you can quote me studies, of course, it could be my word against yours. If I say, oh, there is no deterrence, and you could say there is deterrence, but we'll require hard facts and data to say that there is actually some deterrence, right? Yeah.
All right, fair enough. So yeah, we'll open the floor up to all participants. They kindly raise their hands to ask questions if they have any queries. So our first question would be from Mr. Mir Sayed Latif sir. So Latif sir, please ask your question.
Mr. Anubhav, I'm really thankful for a very informative and very educative session. And really, all appreciation. It was really well. I mean, we could understand it very well, at least me. And I would like to convey my thanks to Mr. Fahad Malik, who has been very instrumental in bringing such lectures. And it is really from the bottom of my heart that you have really well explained the whole topic. And the I would again like to convey my gratitude, my thanks, my greetings, my applause, everything for you. It was really educative. It was really educative. See, questions and answers are okay, but when you are a very good teacher, you don't ask questions, you understand those. So I think I, as your student, have understood all your the topic so well, and I'm really enlightened by your real intellect and your knowledge on the subject.
Thank you.
Thanks once again, and I would like to thank Mr. Anubhav once again, and we would wish to have him more and more.
Definitely, sir. It was a very lucid lecture, but again, I don't know how many times we would have to thank you, sir, for taking time from the bench and giving some time to us and sharing these lectures and your wise wisdom with us, sir. Thanks a lot.
God
And thank
bless
you
you
for
all. God
always
bless you,
encouraging us.
Anubhav. God bless. God bless.
Thank you so much for your kind words, sir. It mean a lot, and it's indeed been my privilege to be here and to be able to share my views and opinions and my research. And once again, thank you. I mean, I am sure, um, uh, uh, as Fahad has said, that we have benefited. The group has benefited a lot from your support. So once again, thank you so much.
So
Really,
kind, so gracious of you, and love you both. Fahad is
Thank you, sir.
otherwise a buddy, and he is a sweetheart. And you being his friend, you are equally a sweetheart.
thank you.
And all the
Thank
best. All the
Okay.
best.
So we'll encourage other members to also raise questions by raising hands, of course. So anyway, we'll take the conversation forward on the deterrence part. So your opposition to death penalty primarily, as I understood, is a procedural one in which you say that because the procedure is so demanding or unfair in itself, we should not care about the substantive part of justice, because in fact justice is happening in the procedure. But wouldn't that ring true with other punishments as well? Why specifically death penalty?
That's exactly what I said. That there is a difference between other punishments and capital punishment. And while a person who knows that they could be imprisoned, or if they have been in prison for too long, that punishment could be set off against the final punishment as well. But in case of capital punishment, that is not the case. B, more importantly, as I said, that I based my answer on the terror management theory. As individuals who are living in the free world, we are not at this moment thinking that this is the date on which our life is going to end, and that is precisely why we are able to have this conversation without fear, because there is no mental uh, torture, if I could say so. Because if Fed, you, or if I think that a certain date, let's say a week from now, is the last day for an individual, it's going to change things. And when the duration becomes so long and the person has no certainty as to how the process and the outcomes are going to work out, they do not have adequate legal representation. It leads it leads them to a point where, generally, and there is a new framework to study capital punishment, which is through the framework of mental health. And psychologists are very helpful in this. The point is that sooner or later, uh, people on death row convicts, they lose their mental stability, and this happens in if I can say that it happens in a majority of cases when the duration is so long, and the constant thought is that you never know how long you're going to live. So that's what basing my answer as to how it
Right.
is different from other
All
punishments.
right. I think Mr. Riaz Vani wanted to ask a question. He has raised his hand. Mr. Vani, if you can hear me, please ask your question. Oh, I think we've lost touch with him. So anyway, let's take a hypothetical situation. Isn't your argument then that if the procedure is fair, the trial is fair and less time taking, then maybe to meet the ends of justice, a capital punishment would be fair in itself as well? Or do you presuppose that such a situation is not possible in the first place?
I think it's akin to saying that if you want to reduce judicial pendency, we should have more judges. We all know that judicial pendency. It's easy to say that have more judges, no judicial pendency, but it does not
No, no.
happen.
I'll intervene here. Then we should have judges like Mr. Mir Said Latif, because
Uh,
the people who have seen him working would know that we don't need more judges. We need more judges like him. Then yeah. So
and
continue.
and yes, we'll need significant investment. That's a bit, right? But I think
Yeah.
the manner in which this system functions, one who is privy, and I know you are privy with how the system functions, right? And this is not only about capital cities, whether it be it in Srinagar or in Delhi or other places. We're also talking about small places where trials go, right? Therefore, my opinion is that it is difficult to curate a system which is fair enough to stand to satisfy the requirements of Article 21 and Article 14. That's the least I would say. That it's not just some efforts will not. You have to have a system which satisfies the requirement of 14 and 21, which, in my opinion, is fairly not possible.
So you're saying it's not possible at all.
Yes, I mean, in light of social reality, not in an ideal case. Ideally, we can write scores and scores of literature coming out from the Supreme Court, right? We have had phenomenal judges. Krishna Iyer can
Yeah.
write, Bhagwati can write. There's no denial of words, but the fact that those words do not really translate, even after 70 years, by themselves. So, my sense is, considering the data that is coming out from Project 39A, the kind of people who get it, the procedures that go, the durations that go, looking at everything cumulatively, I think it's very difficult.
Fahad
All
Saab,
right.
if
Yeah.
I'm given a chance, I would like to
Yes.
sit in the class of Mr. Anubhav and be his taught.
That is up to him, sir. That is up to him. I'm sure
See,
that will
if
be an honor for him as well.
I said if I would really get a chance, I would really love to be his student, and I'm otherwise his student, but I would really love to be in his class and sit as a if not a backbencher, but I would love to sit in the front row so that I could be more attentive to his nice lectures and all. See, God bless you, Anubhav. God bless you. Uh, really, we are enlightened on this subject in the true perspective, I should say. And thanks once again to Fahad ji for having invited you, and we are all blessed to have you. Thank
Thank
you
you so
once
much.
again.
Thanks for your
Fahad
encouragement
Saab,
again.
thank you once
Yes,
again, and God bless you, my dear.
and you always humble us to the point that we don't know what to say
Thank
next.
you.
No, sir, no, sir. Really, see, we are really enlightened. I would say
Thank you.
on the subject that then talking of the law, talking of various doctrines, and more of the data you have given. See, that
Yes.
is very important. The dependency wise, the year wise, and then talking of the Machi Singh judgment, then the other judgment. See, personally, see, what I feel is that
Yes, yes.
capital punishment should be done away with, because there is a lot of scope for retribution. And retributive theory of crime would always be better than the deterrent theory of crime in the present day scenario. That
All
would be
right.
my personal view. And because retribution is always, see, a person, if you find a person who is young, who commits some crime, and he deserves to be rehabilitated rather than to be punished for a sin or for a crime which he doesn't know what are the pros and cons. So then putting him, making him a hardcore criminal, putting him in the life or giving him death penalty would always be contrary to
All
the
right.
to the to the law of right to life, and as guaranteed under Article 21 of the Constitution. Anyway, it is
Absolutely.
true that we need to uh, maintain the order of the day as well. But then I feel my personal view would be retribution would always be better than deterrence.
Uh, I think it's spot on, Latif Saab. I think retribution is a much. I mean, I'm speaking about
Reformation.
where deterrence. I mean, yes, there is deterrence, there is retribution, and then there is reformation. Reformation
Yes.
involves rehabilitating a person within the
See, it
society.
is it is only when you rehabilitate, then only you reform.
Absolutely,
So once you
absolutely,
rehabilitate, you give a sense of rehabilitation, and reformation is always to come. It has to follow.
absolutely. Yes.
And then the repentance. See, a
So,
person, if you expect a criminal having done a crime at the age of 21, he doesn't know in the
mm,
real sense what you call
mm,
the stricto sensu sense. He doesn't know what he's doing. But if
mm,
he's put in the jail for 5 years, 10 years, facing the trial, then those 10 years, then after 10 years of trial, you put him to any of the capital punishment or you give him life. I feel personally that you would be denying him a right of retribution. You
That's true.
snatch that right from him. There's a difference
Absolutely.
between snatching a right, and I feel so that you would be snatching by putting him to such a rigor of life sentence or a capital punishment. Uh, I personally feel that you deny him the right of reformation and retribution.
mm.
And that denial of right would be, in my humble estimation, violative of Article 21.
So, Latif Saab and Anubhav, you can also join in on this aspect. We'll take a question from Advocate Fayaz Saab, then
Okay,
we'll come
please.
back to the
I'm
conversation.
humble just because the topic was so interesting and I mean, spoken and well done, that you don't feel like moving out of the house.
Absolutely. Absolutely. We'll continue the conversation.
No,
We
no,
won't
it's
let you
okay.
go, but we'll,
Farji, you please
yeah.
continue. I know the
Fine.
the time constraints and other things,
Yes.
but I would like to convey my thanks once again. God bless you.
You are completely humble, sir. Mr. Fayaz, if you could ask your question, please.
First of all, it's an honor for all of us that Honorable Member Mr. Said Latif Saab is also watching this. He's also available on the platform, giving it enlightens all the juniors. Especially, I'm humbled that such a great personality and such a wonderful judge. He's a jurist in himself, as we all know. Mr. Anubhav, as you were talking about retribution, deterrence, all these things, but at the same time, if we will go by command theory, which is not bound by conditions regarding its applicability. This theory weighs equally innocent or not, and proves that for a person culpable of murder, the death penalty is still an immoral punishment, even after taking into consideration deterrence and retribution. Now, as you are discussing purchasing judgment, other judgments, now the collective conscience of the society, which is being used in all those judgments, where the death penalty is being imposed, like we have the case of Afzal Guru, the same stance was taken by the Honorable Supreme Court in order to satisfy the collective conscience of the society. The execution was that the death penalty was avoided. Now, as Mr. Honorable Judge, Mr. Said Latif was rightly saying that if a person is committing something, he is not in a complete state of mind at that point of time. Maybe wittingly, unwittingly, something happens and he commits an offense of heinous nature. Now, avoiding a death penalty for him, we have found that it has not acted as a deterrent at all, because the offenses are repeatedly committed either in one state or the other, either by one person or the other. Now, how will you advocate? What will be your stance with regard to the implementation of those death penalties? Whether this should be the law of the land that every heinous offense, which in the estimation of the public should not be spared, should it be implemented in its letter and spirit, or should the theory of this retribution be implemented in its letter and spirit? That will be my precise question to your good self, so that we will also get enlightened your thoughts, because you are working in a different system. We are practicing the law. We go by different stances. Once as a teacher, you are teaching the students. Your understanding of things is altogether in a different manner. So I would like to have your assistance on that. What must be the rule? What must be the role of the teachers and the students? Because the students are the pillars of the nation. Tomorrow they will be on the forefront. Who will have a wonderful say, like our Honorable Mir Said Latif Sahib is there. His words means a lot. Maybe we may speak many things, but once a judge says something, that matters a lot. Now, what will be your take on that aspect?
Yes, thank you so much, Fayaz Saab, for your question. And indeed, it is, I would restate that it is an honor to be speaking before Latif Sahab here. And I'm thankful for this opportunity and that he has joined. And on the question of, I think there are two parts. One part you spoke about the command theory, that law is the command of the sovereign backed by sanction. And once it has been stated to be the law, it is the law. Yeah,
Yeah,
irrespective of whether you agree to it or you do not agree, because that's the stated law. That's part number one. And the second point that you very rightly mentioned is the question of the role of public's conscience, and how would you deal with those crimes with which the public deems to be heinous. Would I, as an individual, support death penalty in that case? Now, I will answer these two parts. On the question of law being the command of the sovereign backed by sanctions, there is scores and scores of literature on why the command theory is fallible, and why the command theory does not may not always hold good. It is true. In fact, when you look at HLA Hart, and this is Austin's theory of law as command of the sovereign. HLA Hart has written, especially chapter 3 and chapter 5 of concept of law. He has just gone into criticizing why this law is the command of the sovereign backed by threat is not a good definition of law. I can't go into detail at this moment of what are the problems with this definition, but what I will say, that even though law is the command of the sovereign backed by sanctions, I am fully free to disagree with the very nature of that command, whether I agree that it is a legitimate command or an illegitimate command. How do I do it? I may depend on natural law theorist, right? Maybe I would depend on Fuller, for who in context of Eichmann theory, Eichmann question, he said that even though Eichmann, now I'll give you an example. Eichmann was in Hitler's army, and Eichmann was caught in Israel in early 1960s, and then Eichmann's trial started for all the crimes that Eichmann had done during the World War. Eichmann took the stance that I was simply following orders. I was given orders by Himmler, who was Hitler's junior, and I was just doing what Himmler asked me to do. Therefore, these are commands of the sovereign, and I'm bound by them. But the court said no. Court did not agree, and they sentenced him to death again in that case. Therefore, this command of the sovereign can be countered through natural law theory, through other forms of theory, right? So I mean that's one part. Now the second part of the question as to what about public conscience, even if you apply judge made law and say the law made by the judge is the final law, this but Machi Singh doctrine has been declared to be per incurium in Santosh Kumar Bariyar case. It is it is unfortunate that trial courts continue to depend on Machi Singh doctrine whenever they have to give that penalty. And this is there's a study that has been conducted on all on by Project 39A on state of Madhya Pradesh and how they depend on, if I remember correctly, on how they depend on Machi Singh doctrine and how death penalty is given out in those cases. Therefore, even by that logic, public conscience should ideally not feature in this. Now, why it is problematic is because once public makes it mind that they want somebody to be uh, to be hanged, it's very difficult for even the executive, who we very well know that executive needs to heed to the call of the people because there are political reasons involved as well, right? Because eventually the executive is coming out of the legislature, and legislature is formed on the basis of elections, so they need to heed to the call. But it is the judiciary which who is only accountable through the reasons that it gives in the judgments, and those reasons have to be sound based on constitution, criminal law, and the precedents that have been set under the constitution and the criminal law. And therefore, in my opinion, I think judges should follow the precedent and in which has been laid down in the previous case. They should not base their arguments on public conscience alone. And I don't need to go into the debate because, by your very logic of command theory, they have been declared to be per incurium. So public conscience should anyway not feature, is what I would say. Whether heinous crimes, non-heinous crime, irrespective of that classification.
Okay, thank you. So nice of
So
you.
Thank
thank
you.
you. So yeah, where I wanted Latif Saab's opinion also was that what is interesting is that probably the four runners of democracy in the world, United States and India, is exactly where these debates are going on, and death penalty remains to be on the books, and occasionally it is also implemented. So from a sociological point of view. It does mean that death penalty is immensely popular among the masses. People believe it as some kind of good retribution, and of course, it's in our religious laws as well. So, what makes it so popular um, among the people of the world? Yes, that obviously democracies have to go a step ahead and implement death penalty or keep it on the books.
See, Fahadji, as you said that, see, why we should concentrate on this, that why a person commits a crime first. See, question is why? Do we apply our mind to it? Do we analyze it? Why a person? What makes a person to commit a crime? Okay. See, question is if somebody does a crime, we say retributive theory would be better than the deterrent theory. Coupled with the fact, Anubhavji said that with the details and the data he had collected, that some of the people on the death row are there for 190 months. See, a
Yeah,
person on a death row for 190 months, I would say that first, okay, he has the sentence for him, he has the death penalty, but then it would again be against his human rights to keep him pending for 190 months. Every day he is coming across a day of death for him. As rightly said by Anubhavji, that every day he thinks he's not sure. The only thing what makes him die is that he's not sure when he's going to die. Every day, because he knows tomorrow, it can be today, it can be the other day, it can be 10 days, it can be 15 days. So that is more, I feel, more agonizing rather than to put him to gallows. So my
yeah,
own personal view on it. Okay, true. But then we have to see whether deterrence plays a role or not, or retribution plays a role. See, I think Mr. Anubhav needs to go for the data that what would play a role, whether it would be deterrence or it would be retribution. If people are asked that if you do a crime, if you
Yeah.
commit a heinous crime, then what would be bet? Whether you would like to be go for the retributive theory or whether you would go for the deterrence theory. See, that thing we need to do, and really he has done a lot of hard work on collecting the data, right, year wise. And this is really, I am really enlightened by that.
Yes,
And
the
what I
year-wise
personally
data was
feel, my
very
personal
interesting.
viewpoint,
Yeah.
that right, Fayaz Saab also said that a person is not aware of the consequences when he is in jail, facing trial for so many years. Then after 10 years, he gets a capital punishment or he gets a lifer. See, that is more lethal, and that is more agonizing for him. But 10 years, 12 years, 13 years, 14 years is a good time for reformation, and give him time to reform. Maybe he becomes a good citizen.
And Latif Saab, if I may,
Yeah.
in a lot of cases, I mean, in most cases, when eventually after staying on death row for 160 months, sometimes acquittal also happens, and there are a lot of commutations that happen. So,
Absolutely.
how about what then in cases of acquittals? I mean, it's it's heartbreaking to know that somebody has been on death row for. I mean, I'm not saying that they should be hanged if that's because they've been on death row, but the fact that a person acquitted after 10 years, 12 years, 15 years.
10 years.
See, you can't get his days back. You are absolutely right. You are absolutely right. But then my personal view, I mean, then the otherwise the law laid down by the Honorable Supreme Court and the other courts and all that. My viewpoint would be that we must go for a retributive. We must do away with this capital punishment, because
Latifa, I
question
think
is
you mean reformative.
reformative. Yes,
Rather, I
I
would
I think we
find
must
but
see.
must
There's lot of cry all over globally. Some people are really, I mean, the activists. They say that it should be done away with. Even if see, can there be a worst offense than murder? Murder, there can be no worst offense than a murder, as per as the penal code and all is concerned. But then there also one has to see, like you were talking of Islam and all that, that we have the deterrence theory in Islam, but then Islam has also kept certain exceptions. Even for murder, there are exceptions.
No, what I
That if
meant,
the
Latifa,
family, if the
was
family,
yeah,
if the family of the deceased,
they
the
take blood
they
money.
just
or you
come up, and then they just pardon the wrongdoer, the murderer. Even Islam permits that he can be given pardon. So what is
Yeah,
the
Latifa,
concept? The
I'll take a
concept is
minute.
itself
Yeah.
reformation. Then religion would have not given this concept of pardoning a person, that if his family, if the family of the deceased, or if the family, they pardon the person, so that means there
So,
is a
Latifa,
scope.
yeah, my question was that since there's a large social acceptability of capital punishment as a punishment to certain crimes, is it that humans are hardwired to believe that this is a very viable form of punishment that can be given to certain crimes?
See, there, your own different viewpoints.
Yeah.
Absolutely. See, some people, they may I mean, make a point of that deterrence is better than reformation. But then ultimately, when you talk of the human rights, when you talk of right to life, when you talk of the democracy, when you talk of the present day, the development in the world, then I personally feel my viewpoint would be that let us lean towards retribution.
Okay. So,
I said
Anubhav, what's
lean
your take
towards
on it?
retribution. Even if I said there can be no worst, like Fayaz Saab also said that a person is not aware of his consequences. But question is, give him a chance. 11 years, he does a crime. Undoubtedly, he's an antisocial. He does an anti society act. But then when he faces a trial for 10 years, 11 years, 12 years, 5 years, 7 years, then I feel he gets a chance of reformation. Let us give
Okay,
him a
sir.
chance of reformation. Let us see that he comes out as a very peaceful citizen. He comes out then thereafter as a very law abiding citizen. See, we don't give him a chance. Once we deny him this chance, coupled with the fact that a person has been in incarceration for a long years, 10 years, then he needs to be given a chance of reformation. How many
Okay, sir.
percent do you
So,
feel that
yeah,
they will again indulge into the same act? I personally
not
feel
really.
it will hardly be 2 or 3% who will again indulge in the same act after having faced the rigor of trial for 10 years.
Point taken, sir. So, since we are a little short on time, I think it will be
See,
appropriate.
it has
Yeah,
become, you have made it so interesting, coupled with
that's
the
true.
presence, the gracious presence of Mr. Anubhav,
Yeah,
that it would be a very long drawn discussion, and then everybody will have to skip his dinner then, and that we would
yeah.
not
No,
like to.
I'm sure everyone is enjoying it, but
Anyway,
I think, yeah. So, what I
where
did
I
not,
am once
yeah,
again, I would like to convey my 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 gratitude to Mr. Anubhav and Mr. Fahad for having organized such a beautiful and such a informative evening for all law students, because I feel a law student is always a law student.
that's true, sir.
So
Yes,
God bless
yeah.
you, Anubhavji. God bless you. We wish you again to be here.
Thank you, Latif Saab, and
God
hopefully we
bless.
can
God
stay in
bless.
touch through
Thank you.
that. We can stay in touch and continue our discussion. The academia and judiciary and practitioners, everybody should speak to each other. There's so much to learn from
Yeah.
each other.
Absolutely. Every day is a learning. See, that is why we say that once a law student is always a law
There's
student.
always a loss. That's true because the law ultimately never. It's like a chameleon. It always changes colors and never leaves you.
Absolutely.
Yeah,
Absolutely. And you are always a student. You are never perfect.
yeah, absolutely, absolutely.
You are never
So,
perfect.
Anubhav, yeah, last comments from you, Anubhav, on the same question, on the same tenor of the argument, and then we'll close the session.
But
I
then
think,
before we part,
Yeah,
Anubhav, there's an open invitation for you to visit at least Fahad's place, because
yeah,
uh, Fahad's place would mean us all, because he is the host, and
yeah.
then we would all be hosting you through his auspicious hands.
I,
Definitely, sir. He'll come to me, then I'll get. Then we'll both come
Sure,
to you,
sure,
sir.
sure. So it's an open invitation to you to visit,
thank you.
because now we'll be having nice spring and summer. So anytime in your busy schedule, you can. It's an open invitation for you, please. At
Thank you
least
so
from
much.
my side, through
Thank you so
through
much.
my dear son, Mr. Fahad.
Thank you. Thank you so much, Latif Saab. Sure, I'll
Thank
take this
you,
up.
thank you.
On your question, Fahad, I think the last thing I would mention is that one thing that we must take away before we part is the role of society. And let us stop looking at it in terms of binaries between victim and accused, victim and convict. You have, as Latif Saab had very uh, um, rightly said, I completely echo his sentiments that we need to look at the role that society plays in creation of an offender. Nobody becomes, does a person become an offender by choice, or there are structural issues? And trust me, the answers to reformation as well, or to prevent crime, do not necessarily lie in penal provisions, but they lie in providing the basics of life, like providing education and meaningful education, not just education.
True.
To provide meaningful education, to provide meaningful employment, to sensitize. For example, even in cases of sexual offenses, I mean, I can give you a very simple point of, although sometimes controversial, co-educational institutions whereby individuals can interact and speak to each other. While sometimes it may not be possible, but it in contrast, if that is not possible, then perhaps there should be sensitization of genders towards each other, as to how there is a difference, or there are cultural differences that need to be taken care of, or the fact that how to speak to others and how to behave around others, right? So these little things go a long way actually, and therefore the role of the society, I believe, is crucial in ensuring that the structural issues at least can be dealt with, and perhaps we would have a society where there will be lesser incidents. So those are my final thoughts.
Thanks a
Thank
lot.
So, so you mean to say hate the sin, not the sinner?
Absolutely. I think
Absolutely, absolutely,
hate the sin and not the sinner. Yeah, our focus should
absolutely,
be in removing the crime, and
absolutely.
maybe
Very true.
So
the
at the
similarly
end,
not.
Jesus Christ wins.
But we never hate the sin. We only hate the sinner.
Unfortunately, yes.
If we
That's exactly what
eradicate the
happens.
sin, we eradicate the sinner.
Yes. In every case that happens, we eradicate the sinner and not the sin.
Absolutely. If
So,
we must all join hands to eradicate the sin first. When
yes.
we eradicate the sin, we eradicate the sinner.
Yes.
So we are slowly going into another direction now, Latif. So I think it will take us 10
Anyway,
more hours to
because
discuss the
because the
philosophy of
love and
sin now.
affection is so that you don't want to leave.
Yeah. It has been a very wholesome lecture. I would again thank Anubhav on behalf of the entire team and all
Sure, sure,
participants. It
sure.
has been a very wholesome lecture, and I'm sure all of us have thoroughly enjoyed it. Very easy to understand, very deep insights,
Really nice. Really,
very
really
thought,
appreciate.
very thought.
Thank you. Thank you so
Thank
much for
you.
joining.
So on behalf of the entire team of Codecast, I thank all the participants. Mr. Mir Said Latif Saab, of course, Mr. Fayad Saab, who asked a question, and last but not the least, of course, Mr. Anubhav himself, who gave a wonderful lecture today. And additionally, I'd also inform that this lecture is being recorded, so it will be available on our YouTube channel, Podcast Lecture Series channel. You can, if you didn't have time to join us today, you can always go back to the channel and watch the video. I'm sure it would be very insightful. Once again, from the entire team, thank you and good night.
Thank you.
Thank you all.
Good night.